he has to, when we call of hard working, so when we call of hard, one of the qualities is work hard working or industry. So when he has to talk about industry, we are talking about lawyers who has to sit and read. And I always tell all my juniors that if you don't enjoy sitting, reading and writing, you can't become a lawyer. You can become a very good broker, you can become a very good marketing agent, you can become everything. You can become a politician if you want to talk, like to meet people. But fact, to become a good lawyer, you must have the potentiality to sit 8 to 10 hours on the chair and table and chair. You must learn to sit. You can't move and become a good lawyer. Because what you see in the court, you may not sit, but other than the court, the real life of a lawyer is other than the court. The court itself is not the not it is that's only a place where he's conducting the operation. But ultimately, the real work is in the office of a lawyer. So one thing, which first important thing which lawyer has to do, every client for every client, and this is according to me the master card, is to prepare a list of dates and events. So he must have a strict list dates and events in a strict chronology. So because, and one of the very important thing which most of the lawyers, and this is what I found, because if we are talking of Supreme Court, because we are talking advocate on record examination, so we are basically in an appellate jurisdiction. So whenever you start drafting a petition, in 99% people you will see that the list of dates starts from either the date when the suit is filed or on the date when the FIR filed. Now, this is, according to me, is the most uh, incorrect way of drafting a petition, because every fact has already taken place prior to the filing of the FIR or prior to the filing of the suit. So your facts will have to start much prior from the day one. Now, this is very hard working. This is where the real industry of a lawyer comes in, because he will have to read each and every document. He has to read each and every pleading. He has to relate and find out each and every date on which what has happened. So this is how you prepare yourself. Then he has to, the events will have to be, find out from the documents. And one basic principle which I always tell, don't rely on what the client says, rely on the documents. Because at the end of the day, the judge will decide the matter on the basis of documents, and he will not rely on the oral pleadings. So whatever you may like to say in the court is one part, but ultimately it is the documents which speak. So all your facts must be based on documents. Then you have to apply the law to the facts, which is very important. Therefore, the knowledge of the statute is so important. And if you can't do that, because this is one another issue which always my senior and we always tell our juniors also, that there are intelligent lawyers or there are intelligent people who know law. There are some very good people who know facts, but the real issue is application of the law to the facts, and that is what is most important part of it. Then another part is drafting. So drafting is one of the basic qualities for each lawyer, because he has to have that expression. If you are, yeah, the one of the major problems which I've been finding is basically we can't, and this is one problem, we are not able to write correct English. We know the law, we know the facts as lawyers, but when it comes down to drafting, we are not able to express ourselves. So the entire profession of a lawyer can broadly be divided into two parts. One is the drafting part, and one is the court craft. So one is the appearance in the court. So we talk a lot of things about appearance in the court, but according to me, one of the major event is the drafting. And let me tell you, I had the privilege of being with the top two seniors of this Supreme Court. One was that was Ramamurthy and Company when I joined in '76. One was Suresh Agarwal, S.C. Agarwal, who was one of the top draftsmen, and he was called the walking encyclopedia of Supreme Court cases. I think he was an amazing draftsman, and ultimately became a judge of Supreme Court. And other was R.K. Garg, who was one of the finest expressions. And both of them had one thing in common, was knowledge of law and the way they used to apply it to the facts. Then comes You can advertise today, you can advertise on the web. So these are all rules which have been followed up. Again, we'll get into it, but I'm just placing these points before you right now. And then, but the client relationship is very important. So you have to continue, you see, you have to continuously communicate with the client. And one basic thing which I always tell is that you must continue to inform the client as to what is happening in the court. One of the major problems that we suffer in most of the people, and when most of the people complain about it, and that is where every client has to talk to the that is where the clerk or the munshi comes in, is to have the knowledge as to what is going on in his litigation. So that is very important. Then another issue is your economics and fees. So you have to talk, you have to be very, very clear on your fees structures. What is your market value, or you go by your taxation schedules and all. Now these are all things I'm telling you because these are things important which will have a reflection in your advocacy. And the last, which is most important to me, is your career graph. So if you understand your career graph, what do you want to really want to do in your life? So you will be very clear as to why you are doing what you are doing as an advocate. So normally the career graph of a lawyer is that he remains to be a junior lawyer, or what you call the associate lawyer, for almost like 5 to 6 years of his life, where he joins a law firm, or he joins an advocate on record, or he joins a senior advocate, or he may join a law officer. So he may be with an additional advocate general or additional solicitor general, or solicitor general, or AG's office. So these are the first 5 to 6 years of his career, which goes into. That is where he learns. That is where he sees from his senior, and which go a long way. I would say I had the great privilege of being a junior with R.K. Garg and Suresh Agarwal for almost 18 months before Suresh Agarwal was S.C. Agarwal was elevated as a judge of the Rajasthan High Court. And then I really had a privilege of working with late Mr. Mridul, P.R. Mridul, and there I spent almost like 4 years, 4.5 years. So those 6 years, and that was the time when I was able to use all the knowledge I had gained with Ramamurthy and company, and we had done almost like 5 constitutional matters. So that knowledge I was able to apply in all the briefs in which he was briefed. And after 6 years, I declared my independence. So these are the first 5 to 6 years, which are the formative years for the career. So you have to see what you want to do. Then after, the next is the 5 to 20 years. So where you are working as a solo advocate, or you become a senior associate of a law firm, or you may become a judge of a trial court or a law. But since we are talking of Supreme Court, we normally either we would continue as a solo advocate, or you become an advocate on record, and then you become a senior advocate. So whatever you do today as an advocate, you must keep an eye on what exactly you are looking at. Then after 20 years, you become a senior advocate, or you become a partner of a law firm, or you may become a high court judge, or you become an arbitrator or mediator. So there's another channels which are opening now. And finally, after 30 years or 35 years, there's a possibility that you may become a Supreme Court judge, directly elevation from the bar. Now, these are the things you keep in mind, and everybody, you see, he is looking for his career graph and he's looking for money. So these are the two things that are important. Sorry. So if you look at from your career graph, then you will always be aware as to why you are doing what you're doing. So the entire philosophy, these are the whole issues and ideas which are always on the back of the mind when you are doing something. If you don't have a career graph, you can do anything what you like. So I am talking when I talk, I look at it as a profession with a lot of dignity. And Supreme Court, in fact, is a wonderful place to practice, and I think is one of the amazing places. So now let us start the whole art of advocacy, as we call it further. We'd like to take it further. So, since what I say is that since the beginning of the civil society, all kings and every common man always needed professional help to objectively express his concerns, his interests, and entitlements against violation of facts, against violation of laws, violation of his rights, and perpetrating illegalities, breaches of contract, and trusts. These illegalities, they always some this is a very interesting. The whole in the whole world, like toxins in our body, there are always abrasion in the society. So breach of contracts continue to take place, breach of trust continue to take place, people continue to be violent, so there are violences, there are crimes, there are illegalities. That is that is how the conflicts become disputes and disputes become litigation, so it continues. Therefore the need of advocate has been right from the very beginning, since the time the civil society emerged. Now, back into the history, I'm a slightly spiritual, mythological person. So, I would like to narrate two very interesting issues to you, which reflect on the art of advocacy. So, back into the history about a million years ago, Shri Ram, Bhagwan Ram, we call it, decided to send Angad, his son, uh, who was son of Raja Bali, as an advocate to Ravan to come out with an mediation. So this is where I talk of mediation, and because everybody he was aware, because there was almost like more than 2.5 crore uh, animal warriors on each side, which were going to fight the war. So there were almost like 50 million warriors were there, and the war was imminent. So he sent Angad. So there was a uh, both Sugriv and Lakshman. They came out against it, and he says, "Look, you had killed Bali, so why should you have it?" So then now Ram, he narrates the quality of Angad. Now this was referred to me by Parashran, Mr. K. Parashran was Attorney General, and it was very interesting. And he says, "Look, Karneshwar, these are the things which really reflect the good qualities, one of the finest qualities of a lawyer." So. Uh, so that is what Shri Ram, he told all the people. He says, "Look, let me give you the qualities of that." So the first quality was his presentation as a person, the attire, the posture, the body language. So he was humble, but not meek. He was straightforward, but not arrogant. It was like uh, it was like a seeker, but not passive. And finally, he was casual, but it was not that he was not alert. Now, these are the qualities when you present yourself in the court, it is very, very important as to how you present yourself. That is very, very sad, let me tell you, to see some of these lawyers who doesn't come to the court with in the proper present situation. And in the e-court situation, when this whole thing was going on, webinars and all, it was really sad to see the attires of the advocates. So always be present yourself in a present situation. Then the next important thing was the speed of delivery. So one of the most important thing is the speech. So when you speak, or when Angad spoke, that is what he said, that he will neither speak very fast or he will not speak very slow. So the speed of the speech is very important. Then second thing is the audibility. So you don't speak, the pitch is not that too high. The pitch of the voice is neither too high nor the pitch is too low. Then every word was pronounced perfectly. Now that's very important because ultimately you're not just speaking in a court, which is not like It's not a nukkad ka bhashan. You are presenting a case, sorry, before a court. So when you're presenting your case, the judge has to understand what you're presenting. If he doesn't understand it, the whole presentation is useless. So speech, the speed of speech, the pitch of the speech, and the pronunciation of the speech. And then the voice, it did not contain any accent or inflection. So you have to also be aware of the correct voice, that the way you are using your voice. Then he said that look, he knew which word has to be emphasized and which where to pause. The pausing between the word is again a very important factor which you have to look into. The pausing is always essential to give the time to the judge to digest what you are trying to tell him. It is just not that you just continue to do blah in the courts. So all this comes from, and how does this come from? This comes from self-reliance. It comes from self-confidence, and all this makes an impact on the judge. Another important factor was that there were no movements of his body while making the submission. You see, like some speakers who continue to move up on their toes, or they move their hands, or they move their eyebrows, or they move their shoulders, or they try to put their gown into place. Now these are all factors which disturbs the judge. So you should talk straight from eye to eye without allowing any digression. So that is how you keep the judge uh, focused. The moment the judge loses his focus, your case is over. Then another issue was that Angad was very well read. So he had that knowledge, as we have already discussed, the knowledge of everything. So at that point of time, the important part of knowledge was that he had knowledge of all the four Ved, the 18 Purans, the 18 Upanishads, and political, he knew the politics, he knew the social milieu. But then he would not, but then he would only talk the relevant. He was learned with a deep, insatiable desire to understand the fundamentals as the basis of every issue, but he will never make any effort to brag about his knowledge. He will only speak the relevant and be in control of what he is saying. So sometimes you try to tell judges things which may be off the record, which may not be relevant for the purpose, but don't do that, because there will be other cases in which you can do that. So every case has to be specifically argued like that case. Then he was representing a patron and will always protect his interest. He will not do anything to impair the interest of the client at any cost by perpetuating his own prejudices. Now, that is another thing which sometimes, is a very interesting issue, that the lawyer tries to, he himself identifies himself with the client. Never do that. Never do that. So, maybe Angat, whatever feeling he had, but he says, no, look, that he doesn't have that quality. So, you have to maintain your dignity as a person by representing fearless. And then finally, and that is an art, one of the biggest art, is when you should stop speaking. So he knew exactly, once your point is made, the judge has agreed with you, just stop it. Don't continue to argue after you have already made your point and the judge has agreed with you. But that is most disastrous according to me. Because that may change judge's mind. Let the other side do it. Or let the judge talk to the other side. Then I come down to 5,000 down below after Ram, and one of the most interesting and according to me one of the greatest advocate ever in this world has been Shri Krishna. So Shri Krishna was advocating against a reluctant Arjun between an army of 4.5 million warriors, which was Mahabharata. So Arjun was a very experienced and intelligent warrior, but he developed cold feet and looking to the grave consequences of his actions and what will happen after the judge. So he was unwilling and hesitant. No, he's like an hesitant judge who is not agreeing with you, your what he should normally do. So he was hesitant. So having, it's like a judge who doesn't want to give a judgment. So the judge has been, throughout his life, his basic job is to give a judgment, and he suddenly becomes reluctant. So how do you come across, and then he doesn't want to do exactly the way you want him to do. So Krishna wanted, ultimately the Krishna's purpose was that Mahabharata was had to happen. Everybody had to die. All those people like Bhishma, Pitama, Drona, and Arjun was one of the instruments and one of the more important instruments. So you need the justice to be done for your client. The judge is there sitting there, and he's not doing justice. So how do you persuade him? And you take him round and round and round and round, round and round. Tell him the facts, tell him the law, tell him all the situation, the implications of the facts and the law. And finally, you see that he comes and decides the case in the favor of your client. So Shri Krishna, with immaculate precision and perfection, narrated to him the entire cosmic interplay and resolved the conflicts for all times to come, not ignoring any one of them. So every question that the Arjun raised continuously, one after another, and they're very serious questions. So when the judge asks you the question, you can't look here and there. So you have to be prepared. You have to be thoroughly prepared with your brief. That's the most important thing. And so you can't tell a judge, you can't ignore any of the questions. In fact, one of the worst thing is that you don't answer the judge's question. So the brilliance with which Krishna continues to answer one after one questions of Arjun by shifting his positions from one end to another. So that is how that is how you have to. So this is one of the greatest art of advocacy. So and then the beauty is that Shri Krishna not merely helped Arjun to understand the truth, but also brought about the realization and enlightenment to enable him to see beyond the mundane and the ephemeral and to act to his perfection and joy and enjoy the bliss of action. So Shri Krishna always smiled, developed the argument on his legs, and never told Arjun as to what he should do. Now, that's a very important thing. He never told that, look, this is the order I want. But ultimately, he knew what order he wants. And he was looking for justice. So he took him round everything. And I think that's one of the finest form of advocacy. So people, I would request you all to, look at that character. And he continues to empower Arjun to correctly and exactly decide the way he wants it to be decided. So you have to decide, you see, you ultimately, what is your purpose? That you want the judge to decide in the favor of your client. So that is the way you develop yourself. And that, according to me, is perhaps the greatest art of advocacy, which is unlike dialectics or rhetorics, is prevalent by Socrates or Plato or Aristotle. So this is very, very different. Now, let me tell you something very interesting from my own personal experiences, and I would love to share it here. And that comes from my 46 years experience at the bar. So, let me tell you about the great qualities of the senior advocates of Supreme Court here. So, the moment I began here, it was C.K. Daftari, who was the second Attorney General of India, whom I saw moving slowly with a stick in the corridors of the Supreme Court. He was famous for his wit. So one of the very famous, one of the very powerful or a strong strength of a lawyer is wit. Now wit is basically telling something to the judge in a very humorous way and communicate him exactly the way you would like him to start thinking. One of the classic cases of classic argument, not an argument, but a witty situation of C.K. Daftari was that during Keshwanand Bharti. When he got up to argue, it was almost like 3:30 in the evening, 3 o'clock in the evening, and then the judges continued to fire questions on him, one after another, after another, and after another, and another. He was appearing as the Solicitor General there. So and next morning he came to the court, and he told when the questions started again against him. So he said, "Look, your lordships, may I narrate a small story?" And the story goes like this: that I met a young girl, a student who was who came to the court, and she told me, "Mr. Daftari, I really loved your court because, but the difficulty was I saw those 13 judges sitting there, who were sitting there. They were." They were arguing the case so beautifully, and there was one man who was standing there, and probably it was you, who was again and again interfering in what you were saying. Now the judges got the message that they were interfering too much in what the lawyer was arguing, what Daftari was arguing, and thereafter they just kept silent and they continued to hear what Daftari was saying. Now this is a wit. So by wit you communicated exactly what you wanted to say. So you don't, it's a wonderful way of giving a thought across the bar. Then I briefed Lal Narayan Sinha, who was the fifth Attorney General of India in Rangnath Reddy case. He was extremely unassuming, simple, humble, very precise, and absolutely non-repeating. So now this whole tradition has gone because he would not repeat even a sentence, and the judges have to be very, very cautious while hearing it. So the judges are also, and that is a reputation. So, this reputation of yours slowly develops. And the judges know. And they were always extra attentive when he was arguing, so that they don't miss a word. Then I had the occasion of hearing and Mr. Nani Palkiwala in Minerva Mills case, which I was representing the state of Rajasthan. So he would give easy to understand common examples, very simple examples, and had a total command on facts and figures. So this is another, one of the greatest quality of a great lawyer. Then Ashok is then Ashok Sen, Mr. Ashok Sen was a senior advocate, and he is the longest serving law minister in India, in the cabinet of three generations of prime ministers, Jawaharlal Nehru, Indira Gandhi, and Rajiv Gandhi. He had a memory of an elephant. He could tell you the page numbers of your brief years after you briefed him. And I experienced that, actually. He knew every object and reason of every statute. One, that maybe he was also law minister, but the point was he just knew them. He knew the philosophy of why a statute came into existence. He knew the judgments of Privy Council, federal courts, House of Lords, like the back of his hand, all the judgments. And interestingly, his library was better equipped than the judge's library at one point in time. He has certain law reports which even the Supreme Court judge's library don't have. Then we had Mr. F.S. Nariman, who had a robust common sense. He's very quick in reducing complicated issues to first principles. So that's another art of advocacy. Then Mr. Soli Soravji, again Attorney General, he had an outstanding court craft. I've seen him many matters, which I briefed him, and it was just amazing, the way he would go along in the court, and with the confidence he would put the facts and figures, put the the issues before the court. And then one of the final, my senior, I already referred to Suresh Agarwal, who was retired as a judge of Supreme Court, and moving encyclopedia of Supreme Court. And he would come out with citations, like he virtually knew every citation of every judgment of Supreme Court. Then R.K. Garg, he told me, and he used to he had a very interesting, he had a philosophy of socialism. He used to tell me how to use Supreme Court as a tool for social change. And he continued to argue matters putting up national socialism. And that was a change, the entire change from 1956 to 1990 almost, saw that philosophy getting inbuilt into the Supreme Court judgments. So this is how you help the development of a jurisprudence. Then Mr. Mridul, P.R. Mridul, and he had a wonderful. I don't think there's another judge of and another lawyer in Supreme Court who had that fluency of in English language and oratory. He was an amazing orator. So this is another thing. And one of the basic thing when I used to come from court, I used to, he used to sit down and read. He used to read novels, and any time of any new word which used to come to his in that book, I would hear him, pronouncing it 20 times so that it can, come on his tongue. Now that's the way you have command of the language. So it's not, it's just not simple. Now this is what we call as working hard, or I really call as, your own passion to become a good advocate. So that's about the that's about the art of advocacy from my point of view. The other part we can now deal with. There are two. Uh, the real one of the books which comes in, which been referred regularly, is a book by Justice Perry, which is called The Seven Lamps of Advocacy. And in The Seven Lamps of Advocacy, he has talked about honesty, courage, industry or hard work, wit, eloquence, judgment, and fellowship. And there's another eighth, which is called tact or the court craft, which you will find in Mr. K.V. Krishna Swami's Iyer's book called The Professional Conduct and Advocacy. So if we can slightly, I can elaborate it, but even easy, ultimately you have to read this book by Perry to really understand these seven lamps. So honesty means the quality of, giving true and correct facts, and advice to the client. So that's the first part of the advocacy. And I always call that, and comes from my experience, that one has to be, this is called what we call the legal strategy. So one of the very important part of advocacy is that once the client comes to you, you must create a strategy. You have to tell the client very clearly why he is litigating, what is the cost of litigation, what can be the broadly time that may be consumed, and whether ultimately he is going to get the relief or not. Now, don't think that the client is a is not an intelligent fellow. The clients which come to you, and when they come to Supreme Court, they've already gone through trial court, they've gone through district court, they've gone through high court, and then they've come to Supreme Court. They're very, very intelligent clients. And I've seen some of the clients who would give me the judgments of Supreme Court to me and say, look, sir, these are the judgments. So they are very well, they are experienced clients, professional. Some of them are professional litigants. They know litigation very well. So you have to, the honesty, the more you are honest to your client, the more you will develop good as a lawyer, and you will develop a good practice. So all the facts and pleadings and documents, statutes, judgments, you have to be, you have to understand that. And then you have to be honestly, as an advocate, must be sticking on the record. Now, this is one place where sometimes there's a confusion, or sometimes there's a conflict as to what is the fact and what is the fact on record. I am very clear that as an advocate, you don't have to go into what is actual facts. You have to come on the facts, on what are facts on the record. And you have to be thorough with the facts on the record. And never go beyond the facts on the record. You see, one of the worst thing in advocacy is, and that is where the judges feel most uncomfortable, is when you start speaking off the record. So please be aware of facts on the record. And I tell you, my experience is very interestingly in Singapore. They have come out with what they call the common list of dates and events. So because the facts can never be, I would say they can't be incorrect. There can be no dispute on the facts. There can always be dispute on the interpretation of the fact. Like suppose a document has been executed. Now, unless the document is held to be forged, the fact that the document is executed is a fact. The fact that a murder has taken place is a fact. Now, who has committed the murder, how it was committed, are all different issues. But the fact, the real event which has taken place is something which is undisputable. So facts cannot, you must place the correct fact before the court. And the more honest you are, the more confidence you earn from the court. So that is one of, according to me, honesty is one of the most, and believe me, if you state a fact and the court finds out that your fact is not correct, he will black you out. So never in your career. And the moment you appear on the next time, the judge will always be cautious as to what you're trying to speak. So he blacks out. Now that's a very interesting issue. So the judges are very cautious and they're quite aware as to who is appearing, what he is trying to, and particularly with those lawyers who who want to go up in their career. So and one of the you see one of the basic problem of the facts are they come in bits and pieces. I always call it like the juggler's hat. The client will give you something, then you have to do a lot of mining. So now that is where the domain knowledge of your comes in. That if you have the domain knowledge, like in all of our in my profession, we had a series of questionnaires on almost like all subjects. So I can continue to ask the like in typically in service laws, you can ask the client, okay, what date you joined the services, whether it was by advertisement. So give me a copy of the advertisement, give me a copy of the appointment order, give me a copy of your promotion orders, give me a copy. So he continues to give you documents. So you must know how the service law, right from the date of joining till the join of the day is thrown out, or if there is a service dispute. So you have to understand the entire service law. So how service law proceeds. So this, if you have that domain knowledge, you can be a good lawyer. The next is courage. Courage means uh, courage does not mean that you speak out whatever is comes to your head. Courage means is a quality to to contain yourself in the face of adversity. So there are large number of situations, when the court is against you, the other side is you keep silent. Your turn will come. And when your turn comes, then tell the court exactly what the fact is, what the law is. Never keep the correct facts out of the courts or the law. If you know the law, tell the court what the law is. And in my career, I tell you frankly, we had a lot of issues. I used to appear for airport authority. And the judge used to say, how can you do this? I said, look, this is the law. So your lordship may tell me to go against the law. He said, no, that we can't do. So your lordship will have to decide according to the law. So whatever the law is, the law is. And unless the law is amended, that is the way law is. So you must have the courage to tell the judge, look, your lordships cannot decide or should not decide against what the law is, but this is what it is. So always show the court, but for that you have to be very well read yourself. And these are the facts of the case. And my feeling is 100%. Judges are there to do justice. Whatever you may say, I'm not going on the abrasion. People may say that abrasion, but there are. So what? But in almost like 99% cases, the courts are there to do, and 100% cases, the courts are there to do justice. They are there to do justice. They are court of justice. They're not court of injustice. And if you put the correct facts and you put the law correctly, the court will decide in your favor. I've seen cases in which the court did not agree with us, but when we gave our written submission and all, the judgment came in our favor. So it's not a situation where the courage and we have the capacity to say, that is one thing I think, maybe because I was supported by my spirituality on Bhagavad Gita and all, that I never thought it is a very big issue, because every case ultimately is a case which has to ultimately you have to win the battle. And if you combat with the because ultimately you're trying to move on the strength of justice and truth. So the next is what he says is industry, or what is hard work. That I already told you. So there's so much of thing. You need to study every bit of it. And it's a very interesting, it's very I can give you a very interesting experience, a very interesting illustration on this. That normally in today's, in big litigations, there is a tendency of filing whole huge amount of documents in the court, and lawyers don't read it because it takes time to read the documents. And sometimes you may file a document. This happened in a matter in America, where at IBM against the state, so there's a problem with IBM, and they filed 27 boxes filled of documents. And the lawyer for the one side read it, the lawyer on the other side did not read it, and they filed a lot of documents which are admissions which went against them. So you don't file a document, you don't cite a precedent, and one of the major issues which are coming today is that the judgments are cited reading head notes. Please don't do it. You must know the facts of each case in which you are citing before the court. Don't cite a judgment if you don't know the facts. Please. So this is one of the biggest problem which is coming up, and this is one of the biggest arts according to you must one of the major hard work that you have to do is to read the facts and see how the law is applied to the facts. It may the principle may be in your favor, the judgment may be against you. Never do that. Don't cite a judgment before the court which is against you. If the other side is fighting it, try to find out the reasons of getting out of it. And you can always tell the court, look, these are the five judgments which are against, but they're against me because they've taken a different point of view. But these are all distinguishable, or they can't be applied here. Then the fourth he talks is about wit. We already discussed with it with Mr. Daftari. So wit is humor. So that is the wit. I would say it's not the wit means basically keep smiling. never lose your never lose your sense of being a happy person. Because ultimately, the order will be passed by the judge. You may shout at the judge, you may talk anything to the judge, but ultimately you can't pass an order in the court. The order will finally be passed by the judge. So you will have to be, you have to keep the judge in good humor. Don't try to. Nobody can ever get an order by throwing back at the judge. Never begin. If you lose in the lower court, you can always go to the high court. If you go to lose in the high court, you can always go to the Supreme Court. If you lose in Supreme Court, you can always file a review. You can file a curative. If you have justice in your side, believe me, you will finally get justice, or your client will get justice. So don't lose your patience. Don't lose your face. Not because of fear, but that's not the way it is done. Then another one is eloquence. Eloquence is basically oratory. So you have to be eloquent. So you have to be fluent in speaking. You have to be clear in your thinking. But all this clarity again, this all comes from your understanding, from your knowledge, from your hard work. Then judgment. Judgment, he talks of judgment, but judgment actually here means your decision making. So now your decision making again is to decide what to say when, how to say what has to be said, how to place your submissions. Now these are all part of judgment. So these are when it's like thinking on your legs. In fact, every case, and I've done maybe about 7,000 cases in Supreme Court. I tell you frankly, when you get up in the court, you don't even know how you're going to start to open your arguments. Once you look at the judge, the eye meets, you see some reaction, you see some moment, you see yes, he may say yes, what are you to say, and then you start. So that point of decision making is on the spur of the moment, and there's a judgment. You have to make a judgment on your legs as how to be, how to say what and when, and how to place your facts step by step by step. Because the judges particularly in Supreme Court, they've all read the briefs. So you have to pause for a moment to see their reaction. They've made their notes, and they're doing one case after another case after another case after another case. So every judge makes their notes. So and they have to refer to their note before they look at you and they argue. They want to see what exactly is the issue. And if the issue matches, if you say exactly what he is thinking, you get an order. And if it doesn't, then he would have some queries. Then another issue is the fellowship. Fellowship means how do you deal with your associates, with your colleagues. And that's very, very important. Because in today's there are multiple in some matters there are multiple lawyers, and you don't lose your relationship with your colleagues merely because you may have different you're on the different side in a litigation. Never do that. And finally, it is the tact or the craft. So that is something which one has to learn by experience how to go about it. Then we come down to the next part of the today's lecture, I would say, is the rules relating to professional standards of professional conduct and etiquettes. Now you will find this in the Bar Council rules, which is of chapter two of part six, which deals with rule governing the advocates. So, rule chapter one is restrictions on senior advocates, and chapter two deals with the advocates. And one thing I would emphasize you, every one of you, because I'm emphasizing you because there will be a question. There's a preamble to the rules. If you see there's a preamble to the rule, and I just read the preamble. It says an advocate shall at all times comport himself in a manner befitting his status as an officer of the court, a privileged member of the community, and a gentleman, bearing in mind that what may be lawful and moral for a person who is not a member of the bar or for a member of the bar in his non professional capacity may still be improper for an advocate. Without prejudice to the generalities of the foregoing obligations, an advocate shall fearlessly uphold the interest of his client and his conduct conform to the rules hereinafter mentioned, both in letter and in spirit. The rules hereinafter mentioned contain the canons of conduct and etiquette adopted as the general guides, yet the specific mention thereof shall not be construed as a denial of the existence of other equally imperative, though not specifically mentioned. So kindly read this preamble. Not only read it, I would say learn it by heart, because you may have a full question. You may have a question on the preamble itself. So this I am indicating you. Then you have the duties. The section one, which has got 10. It deals with the duties of the court. So it says the advocate shall, during presentation of a case, while otherwise acting before the court, conduct with dignity, self-respect. So these are all one after another. So you have to read each one of them. So there are total are about 64 of these rules. So these 10 rules are relating to courts, and I'm not repeating it because I've already covered for more than an hour, and I don't think it is reasonable to keep you waiting. So you have to go through these 10 of them, and then there are the illustrations also in which he says the advocate shall not plead in any manner in which he is himself a peculiarly interested. So these are the first 10 rules vis-a-vis court. Then you will see the duty to the clients. The duty of the client goes from rule 11 till 30, 33. So technically speaking, the rules there are 23 of them. So they're almost more than double than what you have to your court. These are very, very important because you must look into this, because client relationship is ultimately you are serving your client. Ultimately, you are in a service industry. So when you're in a service industry and your client servicing client, you have to be very, very cautious with the relationship with your clients. Then there are two rules which relate to duty or to opponents, not to the opponent lawyer, but to the opponent means the client on the other side. So this is rule 34 and 35. He says an advocate shall not in any way communicate or negotiate upon the subject of controversy with any party represented by the advocate except through that advocate. An advocate shall do in best carry out all legitimate processes made to the opposite party, even though not reduced in writing. Like you make an undertaking in the court, that's you. So you may make anything to the other party out in the corridors. Don't make it. But once having make it, you must stick to it. That's honesty. That is dignity. That is your basic constituent. The next is your duty to the colleague. So these are the advocates' who are on the other side. So, but it also includes rules on that you will not solicit for work, advertise directly, indirectly, whether by circulars, advertisements, touts, personal communications, interviews, or other not warranted by personal relationship. So there have been amendments to this, which has come up now because of they've allowed it to do it on the web. So webs are putting a website or and but to what extent you can put it on the web are also there. So kindly read them very very careful because these are become very very important as to what extent you can put it on the web, to what extent. There may be large issues because large people may be violating it, but then that's not the issue. We must to learn what exactly is going on, what is the real rules on this subject. Then you have to. So these are the broad. Then you have restraint on practice, and so these are the broad things. So now let us, if there are questions and answers, I can take up questions and answers. This is so far my lecture is concerned. So I'll open up my chat. If you've got anything in the chat, then maybe we can just. Oh, I see a lot of things on the chat. Oh God. One is not audible. I was audible. Good evening, sir. What is. There's a WhatsApp group. Okay, if there's a WhatsApp group, then I will put all these links in this WhatsApp group. Not audible. 64. 64 as of now. No sound. Oh, you could not hear me?
You are audible, sir. You are audible.
Now I see so many of chat. I could not open the chat now.
You are clearly audible.
Are not these uploaded? I don't know. Sir, can you throw light on the aspect of supplementary syllabus? Yeah, there's some supplementary syllabus, but I think this will be concerned in the next lecture when you're having a lecture on the 7th. Then Deepak Nargolkar and they will deal with this supplementary syllabus. But to tell you very frankly, I found it very unusual because I have not been able to relate much to it. So you may get some questions on this, but they are very, very generalized. Can anyone please share a book he returned? There are some network, I don't know. Seven Lamps of Advocacy. There's an audio book already on the web. I'll put it on the that link also. Voice issue, voice issue, voice issue, voice issue. Can you throw light on the aspect of supplements? The request to registrar is, please share the judgments on this paper. They're already in the syllabus. So the syllabus only talks of those 47 judgments. You can download those judgments. Rule 33. I don't know what the rule would be. Do we have a right of the rules in verbatim? You can download it from the web. All the Bar Council rules are already available on the web. Duty to the clients, duty some, I think somebody already done the job. Good. Can you throw light on the aspects of supplements? So this is supplementary syllabus. Okay, supplementary syllabus. So most of the issues are on supplementary syllabus. I think Deepak and they will deal with you on the 7th. Available someone, please my head number. Or I would say what I will do is if you I give my number here, 9818141. So you add me to the group so I can then put all the data there. Some light on the exam pattern. Okay, that's interesting. Or should I give you the paper? So there will be, there will be some questions which will be objective type, 20 some marks, and some will be longish essay type, and some will be question answers based on the judgments. Divided into three parts. So large number of these mobile numbers are coming. So I don't know. There must be somebody who must be adding up into the group. Anything else? Any question? If anybody wants to ask. Admin branch. Hello. Hello, anybody from admin?
Yes, sir.
What do we do? Over? Thank you. So thank you, everybody.
Thank you, sir.
So, I see the large number of mobile numbers are coming in this chat.
Yeah.
So, I think you'll have to add these into that group. And the speed at which the chat is coming, I don't think I'll be able to read them at all. So, what I think the best will be if there are any questions, then you can email it to us and then we can put it in the chat box. Because today, if there's a WhatsApp group already there, so we can add up on that. What did you say? I don't know. Will your today lecture be available online mode? I missed some of the points. I don't know. I'll try to convert them into a paper and then maybe I can put it on the. I can get the whole document. I'll try to do it before the 7th. Can you share the links here itself? Here itself. Okay. I think that is also a good idea. Not bad. Okay, I put this link. This one link is Kapil Sibbal lecture. Then this link which I've put now is Janak Dwarkadas. Then this is a webinar. This is another. This is a long one, but this is by Justice Deepak Mishra is there, and this is a webinar that we conducted on art of advocacy by an Australian group, along with there were 5 senior advocates from Supreme Court. Rajiv Datta was there, Jiten Sharma was there, and Suruchi Agarwal was there. And then finally, this is a link which I'm adding now to the audio book of 7 Lengths of Advocacy. When somebody has rightly put it out that once this is over, then how do you get the link? So what I would suggest is people can open their links on their laptops so they can keep them and then save them. That's one way of doing it. Otherwise, I'll put it in that group of. If you'll add me to the group, I'll add you to the group. Your group 2022. Okay, I'll got it. But what I would suggest is, suppose I add myself. If I had put it now, or maybe I'll add now and then you can again redo it because people who will join subsequently may not be able to get the link. So your links will be only available till people who are joined till now. But the other people will not be able to get those links. So what I'm doing is I'm putting, there's a blog, one of my blogs where there's a lot of things which I already talked today. So I'm giving you all whatever material I've got here, including BCCI lawyer rules. Okay, I put it in the group. all material or group 2022. Uh, you mentioned 47 judgment. That is paper 3 only, right? Because paper 4 is 64. Yeah, 47 judgments and paper 3. I'm talking only paper 3. I'm not taking paper 4. But that leading judgments itself is a different. That's a totally a different ballgame. So this is only for paper 3. These are misconduct. I've given already. I talked about that list. I'll put that also. So there are more judgments on misconduct. There are judgments on advertisements. There are judgments on strikes. And there will be question. Let me tell you, there will be serious questions on on some of these judgments. So you have to carefully read the judgments. Okay, thank you.
Thank you, sir.
Okay, thank you. So I take a break. Thank you, everybody, and best wishes. Good luck. We'll have more advocate on records now.
Thank you, sir.